Hello. In this clip from our Justia webinar, Logic for Lawyers, Crafting Persuasive Legal Arguments, Ryan McCall explores what legal syllogisms are and their key role in persuasive conclusion. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
So a traditional way of thinking about legal reasoning that I'll address and that I initially taught when back when I first started teaching legal writing courses, this one at UCLA Law in 2020, what is this idea of a legal syllogism? So a syllogism is kind of the core move in deductive logic, and it's when you think about IRAC and CREAC, they're really kind of variations on syllogisms. But a syllogism is a three-term argument where you have a major premise, minor premise, and conclusion. So the major premise is, in the case of legal arguments, is a rule statement, a statement of law. Minor premise is a fact statement that you claim brings the fact or falls within the rule. And then the conclusion is that the fact falls within the rule, essentially. Even as I just described that, you can kind of hear that the thing about syllogisms is they don't actually really add any information that's already not contained in their premises. They're also at a pretty high level of argument, as we'll talk about in a couple of minutes. So they may be self-sufficient in cases that are very simple. Like I always use as the simplest example of a legal problem, a speeding ticket. Major premise is the speed limit is 55 miles an hour. Minor premise, defendant was traveling 70 miles an hour. And then you have an implicit premise that doesn't need to be stated, which is 70 is greater than 55. And then you put the major premise and minor premise together, and voila, you have the conclusion: the defendant violated the speed limit. And that's a totally sound argument. And in fact, that's all it takes. That's why we have automated speeding ticket machines in some states, because the robot knows. It measured your speed as you went by, and as long as the sensors are correct, and it knows the speed limit, you don't really have an argument. So, unfortunately, that's not how almost any contested issue in civil litigation works. The syllogism turns out to be at too high a level of generality. So, if it makes an appearance, it would make an appearance kind of as the sort of the last step before a conclusion, but it shouldn't be mistaken as a self-sufficient argument in most cases. The reason is that the real nub of legal argumentation usually occurs in arguing about the premises. So what is the rule really? How do we understand? How are we to interpret this rule in situations like this one? And then what are these facts? And even if the facts are even agreed upon theoretically, as in when you're on appeal and there's been findings that aren't challenged, there's usually a way to characterize the facts as falling within the rule or not. So once again, you have that mutual adjustment of those premises, but the premises themselves are going to be attacked. So therefore, they need to be defended, and the syllogism by itself doesn't tell you how to do that. So here's an example of a syllogism that maybe is superficially appealing, but not a convincing argument, hence my emoji choice. So major premise: battery requires proof of intent to cause harmful or offensive contact. Minor premise: the baseball player didn't intend to hit a fan when he threw his bat into the stands after being ejected. Legal conclusion: clearly, the player isn't liable for battery. And of course, if you're arguing against this, then you would challenge these premises. For the first one, that is true. Battery requires proof of intent to cause harmful or offensive contact, but that particular rule statement, I would argue, is at too high a level of generality to address this particular case. So, and then the minor premise, didn't intend to hit a fan. You have there, to some degree, this idea of equivocation, where you slip out of the discourse of legal terms and into sort of everyday, more casual language. So it's kind of like, I didn't mean to, like a toddler might say when they hit somebody. Well, that's not exactly the same thing as legal intent. Legal intent is a term of art that has goes back centuries. That's the meaning of it varies by context. So in fact, the relevant intent will be imputed to this baseball player, because just so long as the stands are full of fans, and it's reasonably certain, or that if he throws a baseball bat into the stands, it will hit somebody. So that'll be held to be constructive intent. So you can challenge these premises, challenge how they interact, and then you find that this superficially appealing argument collapses. One aspect of the way legal reasoning is often taught with IRAC and CREAC and so on is that we often overlook procedure.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.